Good morning. I have the honor of introducing our next speaker, who I'm quite excited to hear from. Dr. Mark Hoffman holds numerous degrees, including a BA from Amherst, a Master's of Science from Tulane, medical degree from Columbia, Doctors of Jurisprudence and Master of Bioethics from University of Pennsylvania, Master of Laws and Trial Advocacy from Temple, and an MBA from Drexel University. After medical school, he completed his general surgery training at Beth Israel Deaconess in Boston, followed by pediatric surgery training at the Hospital for Sick Children in Toronto under Dr. Bob Filler, and later transplant surgery training at Cambridge University under Sir Roy Kahn. Dr. Hoffman went on to practice pediatric general surgery and transplant surgery at Tufts University and the Children's Hospital of Philadelphia. But he later switched from practicing medicine to practicing law. And now he's a partner at the Philadelphia firm Ross Feller Casey, where he handles medical malpractice, medical device, and pharmaceutical product litigation. Dr. Hoffman's going to be talking to us about what is discoverable, and so please give a warm welcome to Dr. Mark Hoffman.
Thank you very much. I have to admit that I have a lot to say, but I'm going to try not to say a lot or too much. The topic is, what is discoverable? I want to give the usual disclosures. I have nothing to disclose. This should not be considered legal advice, and it doesn't reflect any of the attitudes, opinions, or statements from my law firm, Ross Feller Casey. Now, we're going to talk about what is discoverable, and what is discoverable fits into a litigation timeline called discovery. And discovery is the phase of litigation that occurs after the pleadings, the complaint, the answer to the complaint, and so forth. And it is largely a portion of the litigation that really has no judicial oversight. It's up to the lawyers to decide what they want to ask for in terms of discovery, and it's up to the opponents to decide what they're willing to turn over. Now, the scope of discovery, what is discoverable? And I'm going to tell you that it's a very broad standard in terms of what is discover. It's, as it says, and this is from the rules of federal civil procedure, for which it is the template for most state rules of civil procedure. The scope of discovery really is any non-privileged matter that is relevant to any party's claim or defense. Now that's a pretty broad standard. And what is the test for relevance? Well, that also covers a very broad blast radius. Evidence that is relevant is any evidence or any fact that makes another fact more or less probable. And the fact has to be of consequence to the litigation itself. So what that means is you can pretty much discover whatever you want from your opponent. Now, there are 5 common mechanisms of discovery, 4 of which are written. Those are the interrogatories, which are just written questions that lawyers send to the adversary attorney, requests for the production of documents that may include medical records, policies and procedures, and so forth. Requests for admissions, which are just requests for a party to admit or deny a given statement, and subpoenas, which are written requests sent to third parties. Where the rubber meets the road is the deposition, and that is where one party gets to sit across, one lawyer gets to sit across from the adversarial party and ask questions. Now, what is the goal of discovery? Why do lawyers take discovery? And as I like to say, a goal without a plan is just a wish. The goal of discovery is to actually build a case, to put together those facts, those contentions, those allegations, which are central to either the litigation of the case by the plaintiff or the defense of the case by the defendant. The entire goal of discovery is to prepare for trial. And trial is really where the rubber eventually meets the road. Now, when I was asked to talk about what is discoverable or is it discoverable, I really thought that I could just stand up here and say everything and then just sit down, because pretty much everything is discoverable. And as I learned through life, it's not really the answer that enlightens, but the question that enlightens. And the better question for me to answer today is, what isn't discoverable? And I think many of you are familiar with some of these items. Peer review discussions and materials are not generally discoverable. They're protected by peer review privilege. They're statutorily protected under peer review statutes. So those are generally not discoverable. There are statutorily protected materials. Those are materials that by statute, in Pennsylvania, for example, we have a Pennsylvania Safety Authority, which has sent materials for significant events, significant adverse events. Those materials by statute are not discoverable. I can't go to the Patient Safety Authority and say, I want all of the materials from this event that was reported to you. Special relationship communications, of which the most notable is the attorney-client privilege. That is not discoverable. Communications between a client and an attorney is not discoverable. Materials under a protective or other type of order. Sometimes parties will apply to the court and say, there are these sensitive materials. They generally don't fall within the ambit of not being discoverable, but we think for either policy reasons or other reasons, they should be protected from discovery, and then there will be a back and forth argument at a hearing in terms of whether an order will be issued by a judge to protect those materials from discovery. And finally, potentially anything a party chooses to fight about. One lawyer asks for materials. The other lawyer says, no, I'm not going to give you those materials. And so the first lawyer files a motion to compel, says we're entitled under the rules of evidence or the rules of civil procedure or under case law to obtain these materials. And then a judge will rule one way or the other whether those materials will actually be turned over in discovery. Now, I think many of you are familiar with the peer review statutes. I went to a number of state peer review statute materials. 2 is a number, so I went to 2 of them. One in Pennsylvania, where I generally practice most of my legal time. And in Pennsylvania, it fundamentally says that none of the proceedings or records from a peer review committee can be discovered. None of the people who attended the meetings can be forced to testify, and none of the materials are either subject to discovery or to introduction at trial. Now, New York, my friend Steve Stilianos asked me about the peer review statute in New York. It came up very casually. I really hadn't looked at that issue. But New York has kind of a funky spin on peer review protection. It tracks what I believe the other 50 states track, and that is that records and memoranda and documents from a committee that is performing a peer review function are generally not discoverable. But if a defendant in a lawsuit decides that he or she wants to speak at a committee meeting about the subject matter of the lawsuit, those statements are discoverable. Those statements are discoverable. And that is, for lack of a better word, pretty frightening. I know of no other state that has that exception. And it really tracks the federal rule of evidence and many state rules of evidence, which say a statement by a party opponent or an admission by a party opponent is discoverable. So it expands that rule of evidence to peer review. Attorney-client privilege, anything you discuss with your attorney is privileged, or a representative of your attorney, anyone from that law firm is privileged. And those communications must be for either obtaining or providing legal services or legal advice to a client. The privilege may be claimed by the client if you're at a deposition and an opposing attorney is foolish enough to ask you, well, what did you discuss with your attorney? Your attorney's going to say, objection, don't answer that question, it's privileged. It's privileged. Now, that privilege has various exceptions. If you meet with your attorney and you bring cousin Ned with you to sit there while you're talking with your attorney, then you have essentially waived that privilege because you've allowed a third party into the discussion. So you have to be careful when you speak to your attorney not to bring third parties into the conversation. Now, I want to talk a little bit about, and I think this is a topic that has been expressed to me many times in terms of peer support, helping one another navigate helping others navigate their way through litigation, being there for each other in what I think can only be characterized as a pretty dreadful time, lawsuit. I must tell you, and this is a throwback to the kind of the World War II, loose lips may sink ships, that telling a friend may mean telling the enemy. And while I use the word enemy with some circumspect, being a lawyer, I don't think it's a harsh characterization of what litigation is all about. I always tell people, when you get involved in litigation, it's a full contact sport, and it really is a pretty harsh environment. Some of you may know that, others may find that out down the road, sadly. It's a very harsh environment, and you have to be careful what you say and who you say it to. Now, I often find, and this is both with plaintiffs, people who bring the suit, and defendants, people defending themselves, that there are these blind spots that people have for what is discoverable. Social media. You would be surprised, I guess, of what people post on social media that can harm either their claim or their defense. Any type of electronic communications, text messages, emails about a case, they're all discoverable. Listservs, chat groups, online discussion groups, all discoverable, all subject to discovery. Discussions with colleagues and mentors, presentation of interesting cases at peer review, at peer presentations, all discoverable. Grand rounds, all discoverable. And I want to tell you about one case that I've handled, and to give you sort of the bare bones background, it involved 3 surgeons. 2 surgeons ended up covering for a 3rd surgeon who performed a laparoscopic exploration on a young woman, 35-year-old woman, who was status post-bariatric surgery, who came in with a small bowel obstruction. He performed a laparoscopic exploration. He left town literally to attend a meeting out of town within an hour of completing the surgery and signed out to 2 of his colleagues, all of whom became defendants in this lawsuit. And those 2 colleagues watched this woman progressively deteriorate from what turned out to be infarcted bowel, sepsis, adult respiratory distress syndrome, and she eventually died. A very tragic case, leaving behind 3 small children. These 2 surgeons decided on their own to send these text messages to one another while this woman was lying in the ICU dying. And it says, "This lady is in ARDS and may croak." And then it says, God, fantastic. She's young. She will probably pull through. Then there's a name there because they called the surgeon who was away at a meeting. So-and-so couldn't believe he missed it. I made him feel bad. And what did they say? LOL. And can you imagine what that question is like as a deposition? Doctor, when you wrote LOL, what did that mean? You were laughing out loud while a patient that you were covering was dying in the ICU. Is that right, doctor? Is that what that means? And then it says, his clinical judgment, and then there's an emoji. It's a poop emoji. One colleague talking about a colleague for whose patient they're covering for, they characterize his clinical judgment with a poop emoji. And it goes on. And they basically, between those two surgeons, criticize this guy for never seeing the ligament of Treitz, because when they finally explored this woman, they recognized that the ligament of Treitz had not been dissected out or identified. And then they write, he thinks he saw it, danger Will Robinson. Danger Will Robinson. They're talking about a colleague like this. And I've had a number of cases where this type of back and forth of text messaging goes on. When I ask for this material, all you have to ask for in discovery via a request for production is any and all text messages or other communications between any of the doctors involved in this woman's care that relate to her management. Now, the defense attorney, he tried to argue that this was peer review. Peer review. And his second fallback position was it's some form of self-critical analysis, which really has no vitality under the law, certainly not in Pennsylvania and in most jurisdictions. And the third was that it was not relevant to any fact and issue. Well, go figure that. The judge, there was a hearing. The judge read these text messages and ruled that we are entitled to get them. And I can tell you that at every single deposition that I went on to take in this case, whether it was a defendant surgeon or the janitor of the hospital, much to the chagrin of the defense lawyer, I pulled out these text messages because they're disgusting. They're disgusting. And so to answer the question, what is discoverable? Pretty much everything is discoverable. You need to be careful with what you say, what you do, particularly after litigation is initiated. And I've stuck to my 15 minutes, and I can't believe I did it. I'm happy to address any questions. I always feel like the voice of doom and gloom when I get up here to talk. I think, there's nothing a lawyer likes better than to be in front of a jury of his or her peers, and you are my peers. I once sat exactly where you're sitting. I've sort of taken a peek behind the dark side. It's not pretty back there, but I hope that what I had to say today is helpful to you.
Real quick question. Anything that is discoverable that you would reveal to your risk department? Can you just talk about what risk, how they involve?
Well, things discussed with your risk management department are generally not discoverable. Risk management communications are not discoverable. As much as lawyers would like to take the deposition of the risk manager or get any of those documents, those really are embraced under peer review. But I think even internally in-house, everybody is very circumspect about what they say to one another. And a sad fact of the matter is that once you become a defendant, you're really put on an island, very much by yourself. And it's a very lonely and scary island to be on.
I had two questions for you. One, along that same line, a lot of us want to do things for performance improvement. Maybe our medicine colleagues didn't handle a patient the way that we wanted them to. How do we express that to our colleagues to allow them to improve without making it a turnaround 3 years down the road if they get sued for that same patient to be used against them?
So is your question, if I understand it, is that there are times when colleagues or you or someone else is not pleased with the way a patient has been managed, and you want to know how do you handle those situations? Is that
Correct, where it doesn't end up hurt. You don't think they're bad physicians, but you want to be able to have a process of improvement. We're always very critical of ourselves and want to improve. How do we do that without harming ourselves legally?
I think the peer review environment is the best way to deal with those kinds of concerns. Because quite frankly, if you're at a deposition, you're deposing the defendant or someone else from the hospital, and you ask the defendant doctor, did you discuss the management of this patient with anyone outside of a peer review environment? And what is the answer to that going to be? Yes, I spoke with the resident about the way the patient was managed. What did you say? The lawyer can say, well, I object, that's peer review, excuse me, but it's not. It's not peer review. The next question is going to be, what was the name of the resident that you spoke with? And the next thing the lawyer is going to get is a notice to attend of a deposition for that resident if he's not already a named defendant, or he or she is not a named defendant. So I think the peer review environment, peer review provides an enormous umbrella of protection. Once you step outside the boundaries of peer review protection, you're basically on your own, and it's all discoverable. It's all discoverable. It's a frightening fact, and I can't say that enough times to people.
And then second question, I know when we have adverse events, you know, we even here at APSA have a way to reach out to talk to somebody about it, to mental health issues. How do you frame that in the perspective of the law?
Are you talking about a way to reach out for peer support? Is that what
Correct, because that would be discoverable as well, correct?
Yeah, I mean, peer support, obviously, you again have to be circumspect. If I were reaching out for peer support, I would want to discuss the case with somebody, because the greatest support I think you can receive from a colleague is, I hear what you say, I know what you did, I understand the decisions you made, and I think they were all appropriate. That's what you would like to do. But unfortunately, none of those discussions are protected. They're all relevant because they may make a fact an issue. They may have a tendency, and it's any tendency to make a fact an issue more probable or less probable. That's a pretty low threshold for discovery, so it falls under that category. It does pertain to a fact of consequence in determining the litigation, so it passes that relevancy test as well. I think you have to somehow dissect out peer support on an emotional level versus peer support on a let's talk about what happened and see if we can't work through this together level. And I think that's a very fine line to walk. Now, you may be asked, somebody may be asked at a deposition, did you discuss the case with anybody outside of a peer-reviewed environment? And the answer may be, yeah, I discussed it with Dr. Smith, one of my mentors, one of my colleagues, my former residency chairman, somebody like that. And the answer is going to be, the question is going to be, well, what did you talk about and what is that person's name? If all you talked about was emotional support with no substantive talk about the case itself, a smart lawyer is not going to want to take the deposition of that person just to hear that the colleague was upset by what happened. But if there's substantive discussion, particularly if there's substantive criticism, that's all discoverable. All discoverable. Go ahead, Kurt.
Thank you. Just a question, maybe not so much legal as judgment, and based on your experience, there's sometimes a lot of reluctance to disclose and to be transparent about complications early with the family, with the patient. And I can recall at least a couple of publications that seem to indicate that that's actually disadvantageous. Obviously, once you have that discussion, it's there with the family. But I'm just curious what your experience has been and what you would advise surgeons in the moments after a complication or in the early period after a complication.
Yeah, there are some states now that are looking at apology statutes. And in other words, if you go to a patient and apologize for the outcome, not apologize for making a mistake or something of that nature, but apologize for the outcome, there are statutes in some states that actually preclude that from being admissible at trial. I think transparency is key. I must tell you that in the cases that I see, and I can't tell you the percentage, but it's a very small percentage of cases that actually find their way, at least through my filter, into litigation. But in the cases that I see, it's patients who show up in a lawyer's office, they've had a bad outcome, and they have no idea what happened in the hospital. Their parent, their child, their brother, their sister was in an ICU. They saw the infectious disease specialist, the critical care specialist, the pulmonary specialist, the cardiology specialist. All of them had kind of a different story to tell. And nobody came to them after the patient either died or had a terribly adverse outcome and explained what happened. And a lot of people, as a knee-jerk response, believe that when nobody offers an explanation, somebody did something wrong. Otherwise, they would have talked about it. I think transparency, openness, honesty is key to dealing with patients. Whatever the outcome will be, whether it ends up in litigation or not, it's impossible to predict. Sometimes it is possible to predict, but usually it's not. But I think a lot of families seek out legal advice because they just have no idea what happened. They have no idea what happened. And they feel like if they don't have any idea what happened, then what happened involved malfeasance in some form or another.
Yeah, real quickly, Mark, I just want to thank you for doing this today, and also thank you for what the folks in the audience may not know is the gift of your advice and counsel to the Wellness Committee and the peer support group as we've developed this in APSA. This moral distress that so many of our members have spoken about, and actually so many members unfortunately have, has perhaps been helped through the peer support program as it has in many other associations. But you have been so true to your APSA roots in being able to help that committee guide them. Just really thank you very much for your gift and for your contribution.
Well, thank you. I also do weddings and bar mitzvahs and grand rounds. If anybody is interested, the price is always right. I just show up and do it. And I think in an expanded talk, there's a lot more to talk about. This just simply scratches the surface about litigation. And I think it's key, and I say this as a surgeon, I think it's critical to understand the process, to not simply be a passive participant in litigation. I always tell surgeons, and I've defended surgeons, and I've had cases against surgeons, I always tell those that I've represented, you are the expert. You are the expert. You were there. You know what happened. You know what the standard of care is. You should be your best advocate. And unfortunately, the defendants are often pushed to the side as a simple pawn in a process that involves them only peripherally. And it's very meaningful to be sued. That, I think we all know. Thank you.
Dr. Hoffman, there's one more question from the virtual audience.
I didn't know we had a virtual.
We do, yes. So one question from them, which is, what if you discuss a case with your spouse who is also a physician?
There is a spousal privilege in most states, but that privilege only extends to when one spouse is accusing another spouse of something, or in litigation involving both spouses. Now, a lot of times spousal privilege will be claimed, and a lot of lawyers will just let it go because they don't know any better. But that spousal privilege does not extend to those kinds of situations. Dr. Stylianos?
Mark, welcome back to APSA. Thank you for what you've brought to us today, and I wanted the membership to know that Mark has authored a primer on medical legal issues for us with key points, definitions. It's very easy to read, if you can believe it, and it's very, very helpful for us to be knowledgeable about what we may be getting ourselves into. So again, Mark, thanks so very much.
Thank you.